See them?
Yeah, great. Is that better?
Yeah.
Right. I think that's us. Sorry, this is the technology problems. Okay, so everyone see those?
Yeah.
It's not that I'm not looking at you, but if I look away, I've got a couple of things I'm going to be looking at. One, the Employment Law Handbook, which has all the legislation in it. Dull, unless you're a geeky lawyer, but also it's also important when you're working in the field. So if you're advising from an HR perspective or from a legal perspective, that you have handy copies of things like the Employment Rights Northern Ireland Order or Employment Rights Act if you're in GB. So it's really just to have an idea of where you need to go to find the law. And really what we're doing in this session is to not look in depth at the law, but to look at the various areas that are more important and how you can find the various pieces of law and be able to advise practically on those. So what we're going to cover is the sources of law, the types of people that you have in your organization, and then look at several areas that are important in the management of people throughout their employment. Now, it's a session that is to be a facilitation session. So, as I say, it's really just to give you an idea of where you can scope out the laws, because I know you've had other sessions and some of your own self-directed learning as well in relation to the specific technical areas. But it's a very dull process to go through unless you're willing to participate. So it's a small group of us. Feel free to come off mute and shout out if you've any queries. Any questions before we start?
No.
Nope. Okay. So the agenda, as I say, is to look at the sources of employment, and this is one that is really important at this level of course, because it's not just understanding the practical realities of managing people in the workplace, but also why do you manage people that way? So where do the laws come from? Where do you access the laws if you need to find out about them? And also to understand changes in law. The second area is status, and we're really only going to touch on this because it was quite topical for a while in terms of employee, worker, independent contractor, self-employed, all of the types of status that you would have in the workplace. But it is ultra important because there's various rights that attract to each of the various employment statuses that you have in the workplace. So you have to understand who you're employing, how you're employing them, and what rights attract to that type of employment or engagement. We're going to look at areas of contract, and that includes what you must provide in terms of contract, but also how you look at various terms, so express terms, implied terms within the contract, because these are things that affect the day-to-day management of your employees. And important to that as well is looking at the variation to contract, because just this morning before we started the session, I was looking with a client on variation of fundamental terms within contract and really just guiding through how that can be affected. I've got a lot of slides on family friendly, but that's really just for your reference, and we'll only be touching on things like the maternity leave, because a lot of the other things within family friendly stem from that. So you don't need to go into each one. So for example, maternity is the same as adoption leave. You're all aware of the other types of leave that you can have, such as parental leave, time off for dependents, you know, and the approach that's taken in the workplace for that. So they're all very policy driven. So when you have your policy, it translates the employment, then you need to know much more about that. But I'm touching on a couple of them because I've also reviewed your assessment for this module. And what I want to do is stop as we go through and touch on some of the things that comes up from there. Not giving you the answers, of course, but to point you in the right direction of what you'll be looking at for each one of those various types of rights that come up under that assessment. And some of those attached to contract, some attached to family friendly, and also some in terms of discrimination. We're going to look at disputes and dismissals, because this is part and parcel of employee relations. So dealing with disputes that you have from employees. So how do you deal with their disputes? And also how do you deal with the disputes that you have as an employer within the workplace as well? Now, discrimination is one of those ones that we'll cover the main concepts and look at some of the protected characteristics. But again, if you were to look at discrimination law, then you're looking at a full day session on that. So we're not able to go into the detail of it, but I will go through the concepts and the various protected characteristics. Redundancy, we'll just look at the differences between individual and collective redundancy, and a fair procedure for dealing with that. And that's now impacted by a case from last week or the week before, which sort of grays the area now in terms of what is individual and what's collective, and that's an EAT case now, not directly applicable in Northern Ireland, but can be persuasive. So this is really just in terms of fairness of procedure. And the final area, just to touch on, because you're not covering this in your assessment, but you need to be aware of when should be would arise in the workplace. So whether there's an outsourcing, whether there is an acquisition of an overall business, acquisition of a business unit, and what that means practically within the workplace. So that's the agenda for today. I think we're scheduled for between 10 and 1. So it's quite tight to get all of these things covered, but we will have breaks so you can go off and get yourself coffee or tea or water or whatever, and just so you can have a bit of breathing space as well from the areas that we've covered. Over to you. Any areas that you don't see up there that you wanted covered? No?
No, not for me.
Okay, is my slides changing? So can you see sources of law up there?
Yeah. Yeah.
Yeah. Okay. So this is probably a very legalistic and nerdy approach to law, but fundamentally you need to understand where the laws come from, and there's various areas that you probably rely on as you're looking at your policies, procedures, or whether you're looking at implementing your the policies that you have, what you need to do in terms of performance management, what you need to do in terms of dismissal. So there's a full range of sources of law that you need to be aware of. Using the wrong button. And the first one is domestic legislation. So I told you it was going to be interactive. So what do you think is domestic legislation?
Currently having a bit of a nightmare with this in terms of the legislation. So my interpretation is that it's the country's legislation, if that in comparison to something like European.
Yeah, I mean I think the key there is domestic, because there's a full range of various things that we have as employers, and that is again still some of the EU law that we have that was enshrined then in GB or NI legislation. But the domestic side of this is how that's been interpreted, how that's been enacted within the various jurisdictions. So again, the issue to be aware of is if you work multi-jurisdiction, then you have to be aware of the domestic legislation where your employees are actually based. So, for example, if prior to doing this job as a lawyer, I was an HR manager, and we looked at a global approach to our policies, procedures, and how we worked with our employees. But we had to be aware of the domestic legislation in each area, because that would trump what we have in terms of our policies. So it's really understanding where your employees are and what legislation attaches to their employment. Any examples of a piece of domestic legislation? Come on, I'm sure you know a piece of legislation.
Bereavement leave.
Okay, and where is that under? See, sorry, you answered now, are you?
Yeah. And I?
Yeah, so specific regulations for that. Yeah. Any others? I mentioned one that you should always have in front of you when you're
Employment rights.
Yeah, so one of the main pieces of legislation that we use as employment practitioners is the Employment Rights legislation, and in GB that's the Employment Rights Act 1996, and in Northern Ireland that's the Employment Rights Northern Ireland Order 1996. And really what domestic legislation is, when you go through law school, you hear about black letter law, and this is really the law that's written down. So if you need to find out a bit about the working time regulations, which is a piece of domestic legislation, you go to the working time regulations 2016 in Northern Ireland, and that sets out what the law says. Okay, and that's your starting point for dealing with any legal analysis. Go back to the black letter law. What does that say? Okay. Then we come on to domestic common law. What do we mean about that? What is domestic common law? Nobody willing to give it a stab? I think. I'm looking at your videos now to see who can pick on. Nope. What happens when you go to court? What happens when you go to tribunal? What do you get?
A decision.
What does the judge issue you with?
Case law, like
Case law. Yeah, exactly it. So domestic common law, unlike places like France, which is a civil jurisdiction, a civil law jurisdiction, we are in a common law jurisdiction. So that's whether you're operating in Northern Ireland, Republic of Ireland, England and Wales, Scotland, places like America, Australia, New Zealand. All these places are common law jurisdictions. And it means that if you have the Employment Rights Northern Ireland Order in front of you, that's not the end of the story. What you need to do in a common law jurisdiction is understand how the courts have interpreted the laws. So the judges, in effect, can say, yes, this is what Parliament has set down as the black letter law, and this is how we interpret it in the legal field. Any examples of a piece of law that was made under common law as opposed to black letter law?
Would the holiday pay case from the PSNI count?
All of those, yeah, absolutely. Those cases, so the Agnew case, which changed the whole fabric of holiday pay in Northern Ireland, is certainly one of those cases. But each area that you look at, whether it's contract law, discrimination law, whether it be working time, the holidays, all have common law interpretations of the black letter law. And it's important you know the key changes, not key changes, but how it's implemented by the legal system in each one of those key areas. One of the ones that's always used as an example is Coleman and Attridge. So this was a disability case where the law said that, you know, it's based on a person's disability, and what the court said was, well, that's not really the full story. It's whether there is detriment or discrimination on the grounds of disability, but it's not necessarily your disability. It can be someone that you're associated with, which is where we got the associative discrimination concept. So that is not written down anywhere in Northern Irish law. It is now codified in GB in the Equality Act, but that was a piece of law that was really created by judges. So the important thing is knowing where to find the black letter law, and then knowing how to find out where the common law has changed that or implemented in a different way. So when you're writing up your assessment, it would be good practice when you're writing down, for example, if you look at one of the areas you're having to look at is holidays. So one of the things that you're covering is one of the employees, it wasn't Olga, it was Amina, I think, had taken holidays but was sick, and then came back and said, I was sick, I want to reschedule my holidays. Okay. Until very recently, that was not to be found anywhere in the black letter law. So what you're looking at there is saying, under the working time regulations, this employee has a right to 20 days plus an additional 1.6 weeks statutory holiday. Okay. But the case law says that in taking that holiday, this employee has these various rights. Okay, so when you're writing up your answer, what you're saying is fundamental black letter laws, working time regulations, but interpreted by the case law in this way. So you're looking at black letter law and case law, and that's where you'll get the higher marks. European law. What do we mean about European law? Where does shout out a piece of European law that is still in use?
Working time directive.
Absolutely, working time directive. So any of the pieces of law that was enacted under European law, so equal treatment directive, that brought in various social aspects, discrimination aspects, the Treaty on Equal Pay, the working time directive. So all of the directives that came from the European Union. Now, those in themselves are not directly applicable if they're directives. So directives allow a member state to enact that in accordance with the directive, but there's various derogations that you can have. So, for example, the agency workers directive, you were allowed to bring in various changes if you wanted as a member state. So in the UK, there was derogations, for example, for the Swedish derogation model. So that could be brought in by a member state or not. So it's really looking at the directive, what it says, and also how it's enacted in the UK. Now, if you look at the working time directive, for example, this is where you get all of the confusion over holiday pay. So working time directive was, quite a short piece of legislation, and it led to the working time regulations in GB and NI. But what you have to be aware of is those regulations must have been enacted in the spirit of the directive. Okay, so in accordance with the directive. So that's when you get referrals to the European Court on whether the legislation has been enacted correctly. All right. So if you're public sector, you were able to rely directly under the directive, but for private sector, you couldn't do that. You have to make a referral to the court. Okay? And that's then where we get all of the changes coming back in terms of Stringer, Paretta, Anjed, all of these different changes that come in through the European courts. Complicated enough for you already?
Mm.
To confuse it more, you also need to be aware that there are various institutions that create codes of practice. And the codes of practice in themselves are not law, but they're used by courts to interpret what the law says. Any examples of codes of practice?
Like ACAS, for example, in the UK.
Yeah, so in terms of what would be the main code there?
But various, but obviously, like, so disciplinary and appeals, for example, they're kind of the guidance as to how we would apply those in policy and
Yeah. Okay.
Yeah.
No, there's various institutions. So if you mention ACAS or our equivalent in Northern Ireland being Labour Relations Agency, then that's where you get quite a bit in terms of your codes of practice. So, for example, as you rightly say, for discipline for grievances, you would look at the code of practice as well as the legislation. In Northern Ireland, for example, we still have the statutory dismissal procedure, and that is also complemented by the ACAS, by the Labour Relations Code of Practice. Whereas discipline and grievance in GB is through the code of practice because the statutory procedures are no longer applicable in GB. So various codes under the Labour Relations Agency. If you go onto their website, you'll be able to click on codes of practice and it'll list those for you. But there's also codes of practice under the Equality Commission in Northern Ireland, and that's codes of practice for the elimination of racial bias in recruitment, in terms of sex bias. You've got a unified guidance in terms of the various pieces of equality legislation. And it's really important for an HR practitioner to understand the codes, because that has to be reflected in your policies and procedures. Not only that, the Equality Commission expect that you will ensure that anybody who's involved in aspects of the job dealing with people management are properly trained in those codes in reality under your policies and procedures. So if you have anyone, for example, that is involved in recruitment, they should be aware of the codes of practice for recruitment in under the Equality Commission. Now, not to be frightened by that, because what you do as HR practitioners is to take all of that information and to distill it down into your policies and procedures for your managers to follow. Any questions about where the law comes from? Nope.
Just one, sorry, and it's more a selfish question. What trumps what typically in those kinds of situations? Obviously, you touched on the European directives and how that's sort of interpreted or applied within domestic legislation or whichever. In scenarios where they may be contradictory, and I guess this is a matter for a court, but typically, what wins?
What wins? It depends on the rights. So, for example, there are pieces of domestic legislation that aren't impacted by codes or aren't impacted by European law. For example, individual redundancy. There are pieces of domestic legislation that are impacted by common law and also codes. Unfair dismissal, for example, if you look at things like unfair dismissal and Polkey decisions, codes of practice for unfair dismissal under ACAS or LRA, or there's pieces of domestic legislation that are impacted by European case law and also European legislation. So it depends on the right that you're looking at. Now, with European law, given that we had the cliff edge at the end of December, where the UK courts no longer have to have regard to European law, but it can still be persuasive. Okay, so you still have to understand what the European cases have said. You've also got the complication if you work in Northern Ireland, because we've got the protocol and the framework, both of which say that there should be no reduction in worker rights as against EU law. So again, should we follow EU law in NI? And certainly there could be an argument in the courts, the tribunal or the higher courts, that we have to stick to the level of rights that's put out by European law. That's all to play out in the next year, so we don't know how it's going to go, or how there's going to be changes to the frameworks, but certainly you have to have regard as to what happened in European law. That didn't answer your question at all, because the real answer is none of them trump the others. They all go as a package.
Yeah, so I think one of the complicated scenarios that I've been looking at recently is in terms of the European law on holiday pay and calculating holiday pay. It works in the UK to an extent, but it really contradicts Irish law. So in my role, we have UK and Ireland together, so I have to look at both. And it's a lot more complicated from an Irish perspective, because they literally contradict each other as to what elements of pay you include in holiday pay, for example. So it's kind of, I guess, until it's tested in the court, until somebody puts a claim in and it's put to them and there's a judgment and then therefore case law, it's really difficult to decide what wins, essentially. But I guess, so you have answered my question.
I mean, I suppose that the answer from an Irish perspective is the EU law will trump, because if it's an EU derived right, the courts in Ireland will interpret their domestic legislation, and it must be interpreted in line with the rights at European level, and that's called the Marleasing principle. So Marleasing said, if there's a conflict between the domestic and the EU legislation or EU rights, then it's the EU rights that trump. So what would happen there is, if you were in the Labour Court and there was an issue of EU law, there would be a referral to the European Court on that point, and then European Court says this is how it should be interpreted from an EU perspective. That's sent back to the domestic courts to implement.
Okay, that makes sense.
Now, the Marleasing principle doesn't apply in GB any longer because of Brexit, but it may still apply to some extent in Northern Ireland.
Okay, that's really interesting. Thank you.
The next thing is because as part of your assessment, you have to look at the various courts and where you can play out your rights. So I'm going to just touch on that, because there are various rights where you can go to tribunals, various rights where you can go to county court, high court, or you can go directly to places like the Information Commissioner's Office or to the Health and Safety Executive. So there's all of these things that you have to be aware of, and there's also the issue of whether you can forum shop. So Siobhan, if you're saying that you work in NI, if you work in across the UK and Ireland, if you have an employee that works, for example, between Northern Ireland and Republic of Ireland, then that employee could have a right to forum shop. So where would be best to bring my claim? Okay. So structure, and I'm going to look at Northern Ireland as a structure of courts, but it's basically the same in GB as well. So we have various courts in Northern Ireland. The first one is the Industrial Court. Anybody heard of that? Anybody been to the Industrial Court? No, not many people have. I think it only sits a couple of times a year, and it deals with union disputes, and it's disputes more about recognition of unions, and also disputes arising from collective agreements. So it's quite rare that it would come up, and it's, for example, where a union put in a right to be recognised, and you say no, and you don't follow the procedure for that, then the union can go off to the industrial court and get a determination there. The main area for employment disputes is the Office of the Industrial Tribunals and Fair Employment Tribunal, or in GB, the Employment Tribunal. Now, we have differences. The Fair Employment Tribunal deals with what? What do you think? What does the Fair Employment Tribunal do?
Equality.
Yeah, so anything to do with what equality? What type of equality?
Religion, gender.
Religion and political opinion. So anything that arises from the Fair Employment and Treatment Order. The Industrial Tribunal deals with everything else. Okay. So if you had a case that was only on religious discrimination, it would go to the Fair Employment Tribunal. If you had a case that deals with religious discrimination and also unfair dismissal or an unlawful deduction from wages, you don't split them. So the Fair Employment Tribunal would take responsibility for all of it because there's a religious aspect to it. If it was for unfair dismissal and unlawful deduction from wages, it would be in the industrial tribunals. Does it matter? No. You'll not see any difference whatsoever in terms of the tribunal when you go there. It's the same constitution, so same panel, although there are various judges and panels that are trained for fair employment only. But no, you don't see any differences. In GB, there is no distinction. It's all through the Employment Tribunal. Unlike GB, we don't have an Employment Appeals Tribunal. So any appeals that we have go directly to the Court of Appeal. And there's a right to appeal to the tribunal, to the Court of Appeal, if the tribunal has erred in law, or whether their findings of fact are perverse. And there's no sifting. So if someone puts in an appeal, then it will be accepted by the Court of Appeal and run. In GB, any appeals from the tribunal on a point of law or perversity would go to the EAT first, and then it would go to the Court of Appeal in England if it was further appealed. Any appeals from the Court of Appeal go to the Supreme Court, and that's either the Court of Appeal in Northern Ireland or the Court of Appeal in GB. But we've also got a bit in between where we've got County Court and High Court, and this is an area that you're asked for in your assessment. These are civil cases, and they are cases that may amount to breaches of employment rights, but in reality, it's around contractual issues. So, for example, in your again, not telling you the answers, but in your assessment, there is an issue of wrongful dismissal. So fixed term contract, you've got this, have you all seen the assessment, by the way? I'm not telling you anything that you don't know. You have?
Yeah, I have. Right,
so you know what you're supposed to be writing about. So in one of these, I think it's Amina. Amina is on a fixed term contract, and there's they're thinking of dismissing her. Now, if they're dismissed, that could be a wrongful dismissal. And for wrongful dismissals, you can either take that in a tribunal, but you can only take wrongful. You can only take a breach of contract claim in a tribunal if your employment is ended. Okay, so you can't take that if you're still employed. or you can take a wrongful dismissal in the county court or the High Court. Why would you do that? Well, if Amina, for example, if her claim is worth more than £25,000, you would not go to the tribunal because that's all you can get in that form. Whereas if she was on £50,000 salary and she wanted to claim all of that, then she would have to go to the higher courts. Right, so it's important that you look at the various claims that someone has and where they should bring those claims. Is that okay? Does that make sense? Or yeah. If you vary someone's contract and they're still employed, but they bring a breach of contract, that cannot be heard in the tribunal because they're still employed. But you can still take an additional claim in the civil courts and still remain employed. Okay, and all you're doing in the civil courts is looking at a quantum for damages and not a statutory compensation. Does that make sense? Appeals from the High Court or the County Court go to the Court of Appeal and then up to the Supreme Court. Okay, so it's the various levels of court that you have. But the important thing to take from that for your learning and for your assessment is that all claims do not automatically go to the tribunal. You can go directly to the County Court or the High Court for some claims. There's some claims that the County Court, High Court will not hear because they're statutory based and they must be brought in the tribunal first. Unfair dismissal, for example. Okay. Any questions about sources or court structure? No? Looking shocked. Employment status, we're going to go into quickly here. Not going to go into it in great detail. Again, there's nothing really in here to do with your assessment, but it is important from a practitioner point of view that you know who is who in your workforce. The main one is an employee, and this is defined under the Employment Rights Order and under the Employment Rights Act. Now, under there, I've got the ERO 230 and 233. That's under the Employment Rights Act and the Employment Rights Order. It is set out in the definitions in Article 3, which I'm turning to now. So under Article 3, there's a definition of employee, which is the same under ERA 230, and this is an individual who's entered into or works under a contract of employment. Okay. Contract of employment means a contract of service or apprenticeship, so it's a contract of service. And whether this is express or implied, so you can't say, well, you're not under a contract because we don't have a written agreement. That will not cut it. It also goes on then to say who is a worker, and this is a 3.3 definition. And a worker means an individual who has entered or works under a contract of employment, exactly the same as an employee, which means all employees are also workers, or any other contract whereby the individual undertakes to perform personally any work or services for another party, but is not in business of their own account. So again, this is saying if you have somebody in the workplace that has to do the work personally, then they're a worker. Okay. So if you look at some of the case law, the Ubers, the Deliveroos, all of this, where they say, is there a right to substitution? Then if there is a right to substitution and it's acted on, then the person doesn't have to do it personally. Okay, and therefore they're not a worker. So it's all very confused, but typically the main people you'll have in the workplace is employees, whether they're permanent, whether they're temporary, whether they're part-time, whether they're fixed term, they tend to be employees. But there are occasions when you do have workers, and I'm going to tell you about the tests in a second. Oh, sorry, trying to get back. So there's various tests that you have to see whether someone's an employee or a worker. Anybody know any of the tests? Shout out if you know any of the tests. No? There's a lot of tests used in the to decide whether someone's an employee or a worker or a contractor, and it differs to what you're actually looking for. So there's different tests, for example, in employment law and different tests in tax law. But if we stick to the employment law, what we're looking at is whether there's what's called the irreducible minima. So this is 3 things that you have to look at to see whether someone is an employee or a worker, or indeed a contractor. So the first one is whether there's mutuality of obligation. Anybody know what that is? Go on, take a guess. No. Okay. Mutuality of obligation is that there's an obligation on the employer to provide work, and also there's an obligation on the individual to accept that work when it's offered. Okay, so it's mutuality of obligation. The second test is whether there's control. What do we mean by control? Well, it goes back to the days of master and servant. So if I can control what you do, when you do, how you do it, then you're an employee. But that's been changed by the case law, because no longer can an employer in very complicated work spheres control everybody. For example, if you're the managing director and you've got a finance manager or director, that managing director might know anything about accountancy. So how are they supposed to control? But they still do have control, because they control how the work is done, the type of work that's done, how it's done, but they don't know the technicalities of it. But they still can control what that person does in the workplace. And the third test is personal service. Okay, so this is whether the individual has to provide the services or the work to the organization personally. Right? If someone meets all 3 of those tests, they are an employee. If they don't meet one of those tests, then they're not an employee. And then what you look at is whether they are a worker. And they're a worker only if there is a requirement for personal service. Okay, so if they meet one of those tests, then they can be a worker. So all of the smart HR and employment lawyers around the around the UK jumped on this and said, right, well, let's write contracts that say that there's no personal service required. So you can substitute someone if you wish. But then came this case of AutoCleanse, which considered those cases where an employer was putting in a right to substitution. And what AutoCleanse said was, that's fine, But what a court is able to do is look outside the contract. So it's okay putting it in the black and white contract, but what we will look at as a court is what happens on the ground. So if, for example, the right to substitution is never used, or whether it's fettered, so whether if there's a right of substitution, I, as the individual, comes to my employer and says, I want to send my cousin to do that next week, and the employer says, no, you can't do that, then that's fettered. So there's no right to substitution. Or whether, as the employer says, well, no, you're only allowed to substitute with someone from my list, that is a fettered right, and therefore up to the court or tribunal to say there is still no right to substitution. Does that make sense? So you're a worker if you meet one of the tests, the personal service, you're an employee if you meet all three. You're an independent contractor if you provide personal service, but you do so on a business on your own account, or you don't meet any of those three tests. So, for example, if I bring, if I engage a decorator to come in and decorate my house, I might want that decorator to do the work because they come highly recommended, but they are on business on their own account, and therefore they don't meet the test of being a worker. So they're an independent contractor. And that's how you tell the difference. Any questions on the tests? Anybody now thinking, oh God, I haven't got my definitions right in work? Because this happens all the time. Who's a 0R contract? Who's a 0R individual? Employee, worker, independent contractor. Who are they? Come on, someone tell me. Which one would you put them into?
Worker.
Okay, why?
Because the company can have control.
Okay. What else in terms of worker?
They can accept the work.
Yes, absolutely. So the main issue for 0Rs is whether there's mutuality of obligation, and typically there's not. So if you're 0Rs, the contract will say that if there's work, we don't have to offer you work, but if there's work and we offer it, you don't have to take it. Okay, and then we'll go to our next person on the list. So if there's no mutuality of obligation, then it's not employee, but it's worker. Okay, so the important thing is to look at the contract and see what it says. I've also put in there agency workers, and they're in a field of their own because they come with their other rights as well. So it's day one rights and 12-week rights. So day one rights having access to facilities, the same as a permanent employee, and 12-week rights such as the right to parity of pay. I'll not go into that in detail with you, but just to set out that they are a status all on their own. And why the importance? Well, the importance is that there's various rights that attract. So contractors do have rights, and they have a right not to be discriminated in the workplace. So this is changing all the time. So I put in the case there of Clyde & Co. and Van Winkelhoff. I only put it in because I like saying that. But this is where Bates Van Winkelhoff was a salaried partner. And therefore, if you're a partner in a law firm, you tend to be self-employed. But the court said, no, in this occasion, because there's personal service, it's grey area whether it's self-employment or whether it's worker. But in any case, a salaried partner has a right not to be discriminated against, whether they're a contractor or not. Okay. You also have a right to a safe and healthy work environment, which is why it's important for contractors when they're coming in that you do risk assessments as well on their working environment. So you might get an IT consultant in to do a project piece of work for you, and they're a contractor, but it means that you still have to have a safe and healthy work environment for them. They have a right to be paid for the work done, and again, it comes down to the contractual obligations. So that is contractor rights as a minimum. Workers have rights, including all of the contractor rights that we've just discussed, but they have EU determined rights, such as Working Time Directive rights. They also have a right to national minimum wage, not to have unlawful deductions from pay, maternity rights, less favourable treatment as a part-time worker, a right to SSP, whistleblowing, unlawful discrimination, health and safety, and a right to be accompanied at hearings. But if you're an employee, you have contractor rights, you have worker rights, and you have all of these additional rights that's set down there. One of them being, and important for your assessment, a right to a written statement of employment particulars. And then you have all of the other rights under there. One of the key things is on fair dismissal, that is only an employee right, not a worker right. Okay, so you have to be an employee to have rights to unfair dismissal. Okay, so I'll leave you to read those rights for yourselves, but it just means that if you're an employee, you have higher level rights than a worker or a contractor. There's also part-time workers and fixed-term employees, and there's rights to in both of those. There's rights to no less favourable treatment, but there can be justifications for that. Part-timers have rights to prorated rights of a full-time worker, and they also have remedies through the tribunal. Fixed-term employees, again, pro rata principle. So you can say, well, a fixed-term employee doesn't have the same rights as a permanent employee where it's justified. But typically, for example, if you're looking at rights to access to pensions, access to certain benefits, then you might have to pro rata that for a fixed-term employee. Okay, so bear that in mind. One thing pointed out in fixed-term employees is this continuous contract. So if you have a fixed-term employee and they have successive fixed-term contracts that go over 4 years, then they have a right to ask that their employment be made permanent. Okay? And it's a right to ask. But you can have justification as to why you're continuing on a fixed-term basis, but it's very difficult to show that after 4 years. If you have an employee that you have on a 4-year fixed-term contract, then you can have a further contract, but you must consider whether that would be permanent. Okay, but because someone is on 4 years, 1 4-year fixed-term contract does not give them the rights at the end of that to ask for permanency. Now, let's move on to employment contracts. Unless anyone has any questions on status. No. One of the key things for your assessment is looking at the fixed term element for AMINA. So just bear that in mind when you're looking at your answers. Now, contracts, key concepts in contracts. Again, pointing out that this is an area for your assessment, is a right to a written statement of employment particulars. Now that's called a Section 1 statement in GB, and it's called an Article 33 statement in NI. Anybody heard of those? Anybody know what has to go into it?
The main terms and conditions.
Okay, like what?
Pay, hours of work.
Okay, pay, hours of work. Easier for me because I've got the answers in front of me, but what else?
Notice and termination.
Okay, notice, termination, yep. All of those points is really fundamental to the employment. So under Article 33 in Section 1, it states names of the employer-employee, date when employment began, but also a date of continuous service, scale of remuneration, method of calculating that, intervals at when pay will be made, working hours of work, place of work, entitlement to holidays, incapacity, so sickness, pensions, length of notice to terminate the contract, job title, whether it's permanent and if it's fixed, the date when that is due to end, place of work and mobility clauses, whether there's any collective agreements, and whether there's employment outside of the jurisdiction that you're working in. So all of those things that must go in. Now, in GB, there was changes to that in 2014, which set out that you have to get things like information about the training that you have to do. So there's a lot of changes that went into the GB statement of particulars. But in essence, what an employee is entitled to get is that statement. And in GB, that's day one, right? Okay, so that must be given on day one. But when you look at the Employment Rights Act, there are various pieces of the information that can be given in different documents over a 2-month period. In Northern Ireland, the employee has to be given the information within 2 months from the commencement of employment. But there's also a requirement that if an employee asks for it during employment and they haven't already been given it, that they be given that within a 4-week period. Okay. So there are various things in a contract. There's the statement of employment particulars, and if you look at the Employment Rights Act or Employment Rights Order, it says what must go in one document and then what must be given in addition to that. So for example, you can mention that there's access to a pension scheme and you can give the pension scheme details in another document. You can mention that there's a disciplinary policy and then give the disciplinary policy in a different document. Okay? But it sets out quite clearly in Section 1 ERA, Article 33 ERO, how that's to be done. Now, that's only the start of it, because that's your statement of employment particulars. That forms part of your contract, but the contract is wider. And the contract is wider because there are other terms that go with the contract, with the statement of contract of employment. What would those be? First of all is express terms. What do we mean by express terms?
Anything in writing, so pay.
Anything that's set down expressly in writing. Okay, so that includes your statement of employment particulars that we've just discussed, but it also includes, for example, if you make any promises in a letter of appointment, or any other written changes that you make to the terms and conditions. But it can also relate to other documents such as policies, procedures, handbooks, where they're said to be contractual, or whether they can be deemed to be contractual because of the nature of how they're applied. And the important thing is, if it's not to be contractual, that you specifically say that in the various policies or procedures. Because if you don't do that, then it's up to the tribunal or the court to decide whether it is actually contractual. And a big thing that comes from this, for example, is redundancy policies and procedures. So if you set down a policy for redundancy where you say, we will do these following things before redundancy takes effect, and you said the policy, the procedure is contractual, then you must do that. If you don't do it, then there could be a breach of contract. Likewise, if you say, we will give statutory redundancy pay and we'll also give enhanced pay, such as 2 times the statutory payments, or an additional week for every week's service, that will all be contractual and you can't get out of that. So for any of those procedures or policies that would lead to such liability, you're always best to say it's non-contractual. Okay? If it's non-contractual, you don't have to consult if you're going to vary that. Okay, but you can vary it by giving reasonable notice. Really important that you review your handbook or your policy and procedures to make sure that you've got that spot on. Collective agreements are express terms. Why is it not a contractual agreement with the employee? What do we think? Who do you make your collective agreement with?
Union.
Union. So any collective agreement that you see, any recognition agreement, will say it's an agreement between X union and X employer. So if it's not between the employer and the employee, it's not an agreement between those two people. But what you see in the statement of employment particulars, or whether it's just unpaid performance, is that you incorporate the collective agreement into the agreement with the employee, and therefore it becomes an express term. So typically you don't see any breach of contract for not following a collective agreement. You would see that through a case against the employer from the union. But you can use collective agreements if they're incorporated to say this is what the employer should have done. An express term is also an oral term, so a verbal term of the contract. What about if I'm the manager and I'm out at the Christmas dinner and I say to my team who's badgering me about not getting a pay increase this year, and I say, look, don't worry, after Christmas, when you come back in January, we'll give you a 10% increase, okay? Is that an express term? Can an employee rely on that?
Yeah.
Yeah. Who's going to say no when the employee comes back in January and says, do you remember when you were sloshed and you said this? What do we think? Is the employer going to issue it? Who's going to say no? Well, one of you have to be willing to say no. If I'm acting for you, I'll say no. And I'll say no on the basis of whether there was an intention to create a legal obligation. And whether there can be intention of someone intention of someone sloshed, then that's open to debate. But my first start is no, that was never intended to be a contractual term. Okay. But also there's the aspect of mistake. So if there's a mistake in a contract, then it doesn't have to be honoured, as long as you can show the mistake and that you have now tried to rectify it. So for example, I had a claim where an employee was issued with a contract as a junior manager, and their salary is put in as senior managers. So all the HR team had done was use a template, and they put in the wrong salary. That person had been getting that salary for a period of 6 months, and they went, oh no, they're getting the wrong salary. How do we rectify it? What would you do as an HR manager?
Speak with the employee
Okay, and say what?
that there was an error on the contract for the salary.
And how could you smooth it where there's agreement?
You could agree not to collect the difference.
Yes.
So just draw a line.
Yeah. Or you could agree to collect the difference, but over an extended period of time, for example. So you could do that, do it by agreement, but you could also, if there's no agreement, say, well, that was a mistake. Clearly we have salary bandings, clearly we have bandings for junior managers, senior managers. It was a mistake contract, it should have been done, and therefore we're going to unilaterally change that and see what the employee does. Okay, so there's all of those things that can be done in terms of express, but also in a contract, there's implied terms. So these are things that you don't see written down. And they can be implied by the way the written statement is performed in the workplace. But there's also implied terms that a court can imply. And these are things that would be such as efficacy. So, for example, there was a case where there was a delivery driver, and what had happened was the employer was changing their base. So they're moving from one location to another. And the delivery driver said, no, in my contract, it says that my place of work is where the old base was, and therefore you can't change it. Now, typically in a contract, if you don't have a mobility clause, then you can't change the place of work without the employee's agreement. So that's why you always see your place of employment is X. However, we have the discretion to change that to any place on a temporary or permanent basis, provided we give you reasonable notice. Right, so you have that mobility clause typically written in. This employer didn't, and the employee went to court. The court said, well, hold on, we have to look at the efficacy of what a contract is there to do. You are a delivery driver, and therefore efficacy would say, by its very nature, your contract is mobile, and therefore it doesn't matter where the base is. You are a mobile worker, and therefore efficacy is we will read into the contract a mobility clause. There's also implied terms if there's an officious bystander test applied. So that is, if I was someone in the street and I looked at a term of a contract that an employer was trying to say was in the contract, or the employee was trying to say in the contract, if I'm an outsider and I say, of course that's going to be in the contract, why wouldn't that be in their contract given the rule? Then that can be implied by the court. There's also a custom and practice that can be implied by a court. Any examples of custom and practice?
We had one where guys were getting a shift premium, but there was nothing in writing, so it just became custom and practice that they were to get that.
Yeah. Always happens in those additional things that's added on. So whether it's an allowance, whether there's a percentage of bonus that's paid every year, whether there's a Christmas bonus paid, whether there's enhanced redundancy, all of these things, if they happen over time, can be custom and practice. can become a contractual term. Now, for custom practice, it has to meet various legal tests, and those tests are that it has to be certain, it has to be notorious, and it has to be reasonable. Okay. So certain in terms of, well, so it wouldn't be certain, for example, if a bonus changes the level it's paid every year. So you couldn't say that the level of bonus is certain. Okay. It has to be notorious, so it has to be well known by the employees. So employees, if they were asked, is this paid at this level, they would say yes, and would be able to tell you when that's been paid. So it has to be notorious as well, it has to be well known. And it has to be reasonable. And it's reasonable in terms of how it's been paid in the past and whether it should be paid in the future. So it has to meet all of those tests. There's also characteristic terms as an employee or an employer, and these are things such as an employee will use reasonable care and skill. They will give a reasonable period of notice to leave employment. They will follow reasonable work instructions. Characteristic terms from an employer, for example, is that you will pay your employees if they do work. There's also statutory implied terms, such as equality terms. So although it doesn't say in your contract that you will give equal pay for men and women, that is implied into the contract of employment. It doesn't say in your employment contracts that you will pay minimum wage, but again, it's statutory implied into the contract that you have to at least pay the minimum wage. Now, implied terms are in addition to express terms, but there's some implied terms that can be overridden by express. So for example, custom and practice. So if you've got custom and practice, but you've got an express term, the express term can trump it. The advice is, as an HR practitioner, you should never want to be relying on implied terms, or you should never want your employees to be able to rely on implied terms. You should write them down. Okay, so you have a full suite of express terms. Incorporated terms we've already discussed. That includes collective agreements and work rules. Now, what you have to do is tailor your contracts as well, because there are certain things that might be more important for you as the employer, and that you want business protections. So, for example, confidentiality. There's a case called Facenda Chicken and Fowler, couldn't make it up, where it says that there is a right to confidentiality during employment. So an employee shouldn't go out and give trade secrets. But if you want protection beyond the end of a contract, then you have to write confidentiality clauses in your contract. So if you want to protect your business secrets, your trade secrets, your data, anything to do with your confidential information in employment, and you want that to extend beyond the end of the contract, you have to have an express term in your contract to protect. Okay, so you'll always have a clause on confidentiality in your contract. Restrictive covenants will not apply at common law, and that is because there's protection of restraint of trade. So if you want to protect your business and limit the restraint of trade provisions, you have to write restrictive covenants into your contract. So this will include things like a non-compete clause, a non-solicitation clause, a non-dealing clause, and a non-poaching clause. But the restraint of trade provisions will always trump a restrictive covenant that isn't enforceable. So if it's not written to the extent where it only protects legitimate aims, legitimate protections required of the business. Okay. For example, if I have a non-compete clause in that says that you'll not work for one of our competitors for 12 months, that is not going to be enforceable. Okay, because what you have to do is to limit it in terms of the sector, in terms of time, in terms of geography. So what would be better there is to say you won't work in a business that competes with ours in terms of the work that you've been involved in over the 12 months prior to your termination, within a 20-mile radius of your place of work, and for a period of 9 months. Okay, so you've thought about that and what is needed for the protection of your business. If you have restrictive covenants that are standard and are applied to everyone in your business, it's unlikely they will be enforceable. What an employer has to do is to turn their mind to what is the protections required of that rule, or those type of rules. So if you have restrictive covenants that are the same for your admin managers, that are the same for your sales managers, not likely to be enforceable. Okay, so you have to tailor your restrictive covenants. You have to look at national minimum wage provisions and to ensure that if you are paying national minimum wage, that you will not apply what's in your contract, but you will tailor what comes out in the changes to national minimum wage. Okay, so if you're paying minimum wage, you put that in, but you will have to tailor that contract to changes that come out. Likewise, in terms of working time, and this is important for your assessment as well, because there's issues of whether Amina is asked to do, and also Olga, asked to do more than 10 hours a day. And if it's 10 hours a day over 5 days, then it's breaching the working time regulations, which is a maximum of 48 hours, unless there's an opt-out. So you can tailor your contract to have opt-outs in it, or whether there's issues over compensatory leave. So, for example, if you're in work and it's a really busy period that you're having with ER issues or recruitment, then it may be that you work over 48 hours that week. And if you don't have an opt-out clause, that's fine, as long as over the reference period, you're not working over the 48 hours, right? So bear in mind that your contracts are tailored in that regard as well. You would also be wise to have variation clauses in your contract, and this allows you to vary elements of the contract, but they have to only be used reasonably. So a lot of contracts in the past would have had a last clause in to say the employer is able to vary your contract in any way on giving you reasonable notice or giving you a month's notice. That is not applicable to all clauses in the contract. It can be applicable to clauses which are ancillary but not fundamental to the relationship. So, for example, you would not be able to use that unilateral clause to change someone's pay. If I'm on 50,000 a year and business is going badly for you and you want to reduce me to 45, and you say, but in my contract, in your contract, I have a right to vary that, I'm going to reduce it to 45. That is not going to work. Okay, so be careful what you have in terms of variation. If you're looking to vary a contract, you have to look at one, whether there's authority under the contract, and if there's ambiguity, such as the St. Mary's case, and that is where it's a wide variation clause, then you have to see how that would impact on the employee and only use it where it is reasonable. If you have non-contractual authority, so whether there's an express agreement with the employee, and this is always the best way to get a variation in your contract, is to meet with the employee and to vary it. There can be an implied agreement. So, for example, if you change the terms under which someone works and they continue to work under that, Then under contract law and this case of Cartwright, then if you continue to work under that, then you will be deemed to have agreed to the variation, and you can't say, well, it didn't apply to me. If you don't have authority under the contract, or whether you don't have any non-contractual authority agreed by the employee, you can also have unilateral imposition. Do not do this, except when you have no other option. This is where you simply go in and say to the employee, I know your working hours are from 9 to 5, but I'm going to change them from 8 to 4. An employee has a right not to agree to that, and they can stand and sue. So they can say, I'm not going to work to that. I'll work to my own terms and conditions, or I will work to that, but I am claiming a breach of contract. So they can sue you while still remaining in the role. Or they can leave and claim constructive dismissal. Okay, so I put in a Northern Ireland case there of McKeague, and this is one where there was a variation in the contract, and Miss McKeague had claimed there was constructive dismissal. And what the tribunal do is look at the rights of the employer, what they've done to affect the contract change, and the impact it has on the employee. And in that case, it was held that there wasn't a constructive dismissal, as the employer did go through a procedure to change and had a business reason for it. So an employee can claim constructive dismissal because of a fundamental breach of contract and sue for dismissal. You also have the other option, which is termination and re-engagement, typically defined as fire and rehire. Anybody heard of that recently?
Yeah.
What was the whole famous one over the last couple of years?
P&O.
Yeah. So the firm I worked in before working in Lewis Silkin acted for P&O. And there is a right to fire and rehire. That's the straightforward position. But it has to be applied with a reasonable procedure. So you can't just go in and say, terminate all your contracts at 50 grand, I'm going to put everybody on 45. That will not be seen as fair. Okay, so you'll have stand-on suits and you'll have constructive dismissal, and the employees will win. To effect a fair fire and rehire, have your business case set out. Why do you need this change? Why is it fundamental that you have this and no other type of change? And then go through a period of consultation. If there's 20 or more people affected by this fire and rehire, it's classed as a technical redundancy, even though the employees won't be made redundant. And you have to follow the collective consultation procedures. And this is what happened with P&O and why there was a whole issue over that. So if it's 20 or more employees, you'll have a consultation period of 30 days. If it's 100 or more employees, in GB, it's 45 days. In Northern Ireland, it's a consultation period of 90 days. All right. And what you do, this is how I do it practically. I have all the employees listed down. I have that they've attended the town hall to find out about the business reason. Tick, 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 tick. And I have individual meetings with them. This is if it's under 20 employees. I explain the business reason to them, and I ask for their agreement, whether they agree to the change or not. Tick X, tick X, 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 tick, tick, tick. All right. So you tick when people agree. Then you take what the employee says, the questions that they have. You go away and you do your investigations. You find out the feasibility of doing what they ask. Then you have your second consultation meeting. You should have more ticks in that column because more people say, well, okay, we agree to it. And then by the time you get to your third or fourth consultation, you might have 1 or 2 X's. At that stage, then you may affect the fire and rehire. So terminate the contracts of those people still refusing and immediately engage in new terms. If the employee accepts that and they come in and they work to the new terms, there's no dismissal. And they can't stand and sue, they can't claim constructive dismissal. They will be deemed to have accepted those new terms. So you can see there it's a very difficult process, and you have to ensure you keep your records right and up to date. Last resort, do not do that without trying to get agreement first. Now, how P&O, if you read the news, got round this was by offering very generous agreements to people. So they got over and above what they were entitled to under, there's statutory redundancy. So it was the same process, only their employees were being made redundant, and they got these enhanced terms. So they were able to agree with the employees that way. So in your termination and re-engagement, always have a process of that consultation. If it's under 20, the way I say to do it. If it's over 20, then it's collective and it's the meetings with the representatives, and it's 30 days. If it's 100 or more, then it's 100 days, or 90 days, sorry. Does that make sense?
Mm-hmm.
Okay, that's variation in contract. National minimum wage, I'm not going to cover that. It's set out in the statutory regulations. It should change every year, and you have to ensure that you update your worker rates. You'll find that on any website, so I'm not going to spend any time on that. Working time, I only want to cover the basics of this, being it derives from a European directive. It's now under the working time regulations, and they were amended in Northern Ireland. So it's the 2016 regulations that we work to here. You have various rights under the working time regulation. The first one is working hours, and it's a maximum of 48. If you've employees, Siobhan, in the Republic of Ireland, there's no opt-out. So it's the 48-hour rule. In Northern Ireland and GB, we still have the opt-out, so people can work over 48 hours if they've signed that opt-out. If they haven't, then you should ensure that someone doesn't do over the 48 hours and to take action to try and give compensatory rest if that's the case. I'm not going to go through what is working time. If you are in an organisation that has any concerns about that, so if you've got peripatetic workers, if someone works from home and they travel to various places for their business, what is work? If you have people that are working on standby or on call, then again, there's various various case law on that, so you need to be aware. There's also rights to breaks, and this depends on whether there's night working. So night working has an overall limit on what of the hours you can do, but also the breaks you have. There's rest breaks throughout the day, which are, who knows what the rest breaks are? What rest breaks are you entitled to?
minutes, 1 hour.
How much, sorry?
20 minutes.
20 minutes, yeah. I think if you work over 6 hours, then you're entitled to 20 minutes through the day, not at the end of the start. And you're also entitled to 11 hours break between shifts. Now, if that's not possible, so for example, if you're changing shifts, there might be that you only have 6 hours. And if that's the case, then you get compensatory rest. And that can come at the end of the next shift. Okay. Record keeping, again, you'll understand that you are obliged to keep working time records for audits by the health and safety executive, and enforcement of breaches of the working time, either claimed through the tribunal or enforcement by the health and safety executive. If someone tries to enforce their rights under the working time regulations, then there should be no detriment. So if someone says, I don't, if someone says I've got a working opt out and I want to opt in, and then they suffer detriment, then they can take a claim on that basis. And also no dismissal for trying to enforce their rights, because that would be an automatic unfair dismissal. Okay. Not going through those. Sick leave, I'm going to touch on this briefly, because this is in your assessment. But 11:30, well, 20 to 12. Can we take does anyone want a 5-minute break? 10-minute break? 10-minute break up, get you the kettle on. So we can back at 10 to 12. Is that all right?
Yep.
See you shortly. Everybody back on? Okay, the joys of annual leave. So a wee bit of time on this because obviously you've got to look at aspects of this in your assessment, but also there's been a lot changing in terms of Agnew and consolidating the case law. So under the working time regulations, there are various parts of annual leave. So annual leave for an employee will consist of what?
Statutory and non-statutory.
Okay, and what would statutory be?
Your minimum entitlement.
Okay, and what is the minimum that you're entitled to under the working time regulations?
I know in Ireland it's 20 days. I'm not sure where else now.
Yeah, so Ireland is implemented the European 20 days. Okay, now because there were abuses, let's say, in terms of that 20 days, in GB and NI, there was an additional statutory amount put in, which is 1.6 weeks. And then you've got your non-statutory, which is your contractual holidays. So you might have an employee that gets 30 days holiday, okay, including their bank holidays or in addition to the bank holidays. Now, how that's broken down, and that's important from the Agnew case, is you've got your 20 days, which is your EU-derived statutory rights, statutory holidays. You've got your 1.6 weeks, which is your working time regulations or domestic statutory leave. So statutory leave in NI and GB is 5.6 weeks. Okay, so 28 days for full-time employees, and that can be prorated. And then you have, for somebody who's on 30 days, your additional 2 days contractual. Now, the important bit about that is there are various rights that attach to EU-derived working time, additional, and contractual. Okay, so for contractual leave, you can give people, an extra 40 days holiday on top of their statutory, but agree not to pay them, or agree to pay them £1. It's contractual. You can do whatever you want with those days. So I had a client yesterday that has just implemented a policy where there is no limit on holidays, but it's what they do in terms of payment, which is the important bit. So where we stand with the working time regulations is that you've got 28 days, and that can be 28 days inclusive of public holidays. So the minimum holiday someone gets is 28 days. But typically, an employer will give the 28 days in addition to the recognised public holidays. Okay. So what does that mean in terms of payments or accruals? So it used to be, when I was in HR school, that if you were absent for 13 weeks or more, you didn't accrue holidays. Okay, your holidays ceased. That changed on the basis of being off on statutory leave, so maternity, adoption, things like that, where your holidays did continue to accrue. Okay, But it also changed then with the implementation of the Working Time Directive, which said, no, you're entitled to your leave or to accrue your leave on the basis that you're a worker. So you don't have to do any work to attract those 20 days. So what happens is you accrue those days as you go through. So in year one, you can have that prorated. In your last year, you're only entitled to what you've accrued up until the time you leave. You can't pay someone for holidays where they don't take them. So rolled up holiday pay was then unlawful. So you can only pay an employee for holidays when they take it, unless they leave and they've holidays accrued, in which case they're allowed to have those paid even though they're not taking them. But there's a whole range of deviations from that because of case law. And the first one is when you can take holidays, or when you can carry holidays over. So typically you can say to an employee, you can't carry over holidays from 1 year to the next, or you can carry holidays 5 days, but not to take you below the statutory amount. You have to take your statutory amount in any 1 year. Okay. Now, there's new case law this year that says that that is an obligation on the employer to make sure that the employee takes them. So, for example, if someone works really hard throughout the year and they haven't had a chance to take them, at the end of the year, you say to them, sorry, you've lost them. That's no longer going to be possible. What you have to do is you have to write to your employees and say, so like at the end of Q3, say you've got another 10 days holiday to take. Make sure you take them in this quarter. If you don't, then you'll forfeit them. And as long as you do that and you encourage people to take them, then you can they can lose their holidays. But not in certain cases. So if they're off on statutory leave, such as maternity, then they have a right to carry those over to the next holiday year. But they also have a right now, if they're sick during the holiday year and they haven't been able to take their holidays, that they can carry them over. All right, and that comes from the case law of Stringer, Peretta, Schulte, all of those cases that you'll be aware of. If we take sickness, which is one of the areas that you'd be looking at for your assessment, an employee has a right, if they're off sick, to accrue their holidays. Okay? So even if you're off sick, it doesn't stop the accrual. If you're off sick that straddles the holiday years, you're entitled to use the holidays that you've accrued when you come back. But there's limits on it. So the limits are, it used to be you could accrue all of your holidays and take them over every year. And the European and the domestic cases said, no, the purpose of holidays is for rest and relaxation. And by accruing, 3 years of holiday and taking that doesn't add to your rest and relaxation, and it's a burden on the employer. So there's a limit now where you can only carry over a rolling 18 months of accrual. Okay, not 18 months holiday, but 18 months of accrual. So if you're entitled to 30 days, then you're entitled to carry over an accrual of 45 days as it goes through. If the absence lasts longer than 18 months, then it starts to chop away at those days. Okay, so you're only ever able to carry over the 18 months accrual. And then there's limits that can be put on when that's taken. So you can say it must be taken within the 15 months after the end of the holidays. But there is that right to carry it over if you're sick. But there's also rights if you're sick before your scheduled holiday. And Peretta said that if you're sick before you go on your holiday, then you have a right to say to your employer, I'm sick, I can't take my holiday then, I want it to be rescheduled. Okay, bear this in mind for your assessment. But there's also the case of ANJUD and FASGA, which is a European case, it said, but that's also the case if you become sick when you're on holiday. So if someone says, such as in your assessment, Amina, I wasn't able to take my holiday because I was sick, then the employer has two options. The first option is to say, no, your sickness didn't stop you enjoying your holiday or stop you from having rest, relaxation, and leisure, and therefore we're not going to pay you. But that's very risky. You would have to be able to specifically show that the person wasn't that sick that they couldn't enjoy their holiday. So the second option is that you allow the employee to reschedule. And your strategy for doing that would be to ask for medical certification that the employee was sick during that period, and therefore the period when they were sick and supposed to be on holiday is reallocated as sickness, and they have a right to reschedule holidays at a later date. And you say, well, that's going to be open to abuse. And that's the important thing about your holiday policy, in that you're reviewing it to ensure that it sets out certification, and it also sets out that you'll only receive your payments that you would receive if you had been sick. So someone, if I go on holiday and I say, well, I was sick for that week, and therefore I want that classified as sickness, and I want to take my week down the line. If I've been paid for that holiday pay can be recovered by the employer, and their sick pay put in place. And if that's SSP, then an employee is very unlikely to say, I want to reclassify it. So that's your first strategy. Okay, and the second strategy you have is to record it as sickness, and that goes on the sickness record, but also, again, to ask for that certification. So if you're sick before your holiday, you can reschedule. If you're sick on holiday, you can reclassify and take it at another date. Okay, important for your assessment. So that's the cases of PREDA and ANGED. So it's a Spanish name, but that's the acronym for it. ANJUD and FASGA, FASGA. So all of that means that an employee then can take that. Now that's all case law, but if you go on to the Lewis Silkin website, myself and a colleague, Kevin Gallagher, had written a piece on changes that came in from the 1st of January this year, which you may not be aware of. And these were changes to the Working Time Regulations 2016 in Northern Ireland. And in summary, what those changes are is that holiday pay must be paid as normal pay. Okay, so that includes overtime and commission, and that's all the case law coming from BA and Williams. And employers should have a reference period of what they're going to cover as normal pay. So in Northern Ireland, if an employee takes a holiday, you look at 12 weeks before and take the average of the amount that they've been paid, and that's what they're entitled to for that week that they take on holiday. In GB, that reference period is 52 weeks. Okay. Now that's difficult because say you work in retail or hospitality, and you've got periods where there's peak times, Christmas, and someone works 50% overtime for the whole of December and January, and they take holidays in February. They're not just paid their contractual hours, they're paid the average of what they had been paid for the 12 weeks before. So that can really increase the amount that people get in holidays. And there's various strategies that you can do. So you can say, well, there's no holidays to be taken in February, or 12 weeks from that peak period. So you can manage it that way. The second bit that changed in January is that it codifies that case law that I'm telling you about, that employees can carry unused holidays in certain circumstances. If they're off sick, if they're on statutory leave, where they haven't been able to take them, where they weren't given the right to take them. And also workers can carry forward holidays that have accrued, but they were unable to take them because of sick leave. So again, codifies all of the case law. And it was done so that the rights wouldn't be reduced because of the move away from European law. Now, another important aspect to that is holiday pay. So traditionally, holidays were paid at basic salary. But all of the case law that you'll be aware of, such as the B.A.M. Williams case, which kicked the whole thing off, and then a full suite of cases that came from that, employees are now entitled to normal remuneration during their holidays. And their normal remuneration includes anything that is intrinsically linked to the job that they do. So for instance, in B.A.M. Williams, Williams was a pilot and his pay was basic pay, let's say £100,000. He also got a sector pay. So every flight he took, he got an additional payment. And he also got an allowance for being away. So he got expenses. So he got his room paid for him. He got his food paid for, all of that. And what he claimed was, when I'm on holiday, I only get my average of the £100,000, and that doesn't reflect what my normal pay is. So the case there said, yes, you have a right to claim holiday pay, or the basic pay, and also your intrinsically linked allowances, which includes the sector. But it does not include expenses, because if you're not away with work, you don't have those expenses. Okay, and that's what's codified now in the changes to the working time regulations. So it's anything that's intrinsically linked. And the regulations set out that the EU-based leave, so that's the 20 days, must include payments of commission, allowances, anything to do with the professional or personal status of the role, so length of service payments, seniority payments, things like that. And other payments such as regular overtime. So if there's been overtime that's regularly done in the 12 weeks before the calculation date, then that must be included. Okay, so that's the changes to the working time regulations. We've also got now the change because of AGNU. And AGNU is in relation to how much you can claim. So if you don't pay me correctly for my holidays, as what I've just set out, I can bring a claim to the tribunal. And that can be for a claim under the working time regulations, but also a claim for an unlawful deduction from wages. In GB, you can only claim back 2 years because there's a backstop. In Northern Ireland, we don't have that backstop, and you can claim right back to the start of your employment or to 1998, whichever is earlier. Does that? Or whichever's later. So if you start in 2005, then you can claim from that your holidays that haven't been paid correctly. But AGNU also dealt with whether there's this 3-month gap. So if you've got an unlawful deduction from wages, if you haven't claimed at the end of 3 months from that deduction being made, then your claim ceases. Or if I pay you correctly, and you wait 3 months from the date when you haven't been paid correctly, then your claim stopped. AGNU said that's no longer the case. And that's on a case-by-case basis. For example, if you didn't know that you haven't been paid correctly, then you still have a right to bring that claim. All right. So AGNU means that an employee can now claim right back to 1998 or whenever they started employment. AGNU also sets out that there's no differences in EU-derived holidays as against the additional 1.6 weeks as against their contractual. So typically what we were saying to employers is your policy should say that the first 20 days that someone takes is EU law, And all of the additional rights, such as their commission, their right to carry over, all of those things only attach to that 20 days. So if the employee takes the 20 days first, and then they take their 1.6 weeks second, and then their contractual last, then it reduces any possibility of a claim. Agnew now says that's not the case. Every day that you take holiday is a proportion of those 3 types of holiday. So if, for example, you get just the 28 days, then it's 20 28ths of a day is your EU, and 8 28ths is your 1.6 weeks. Okay. And it makes it very difficult then to say, well, we're paying the 20 days at this higher rate, and then we'll move to the lower rate for the 1.6, and then to our contractual rate for the additional. You can no longer do that. It has to be in proportion. Now, what all of my clients have is payroll software that can do that for them. So it calculates a proportion of each day's holiday. But the majority of my clients will just pay each day at the higher rate because they don't want the admin burden. Now, this is when I expect you will have questions. Would it be helpful if I sent you the links to the summaries of those changes? I'll send that to Lindsay. It's 2 short articles, one by myself and Kevin, and one by Ciara Fulton in my office. It sets out the changes to working time regulations and also sets out the practical issues of Agnew.
The Agnew bit is the new bit for me, because what we've just proposed is that we do it in the splitting for 1.6 and contractual. So that's just put a massive spanner in about 6 weeks worth of work that's been put together.
Yeah, it's difficult, isn't it, to try and separate those?
It's a massive, and you alluded to the payroll software element to it there. Yeah, it makes it incredibly challenging to differentiate, I guess. And we already have issues in terms of how do you prorata that, leavers and joiners and bank holidays and all of those additional bits.
Yeah.
Out of interest, is just from a best practice point of view for anyone else on the call, does anyone have any commission-based workers? And B, is this a new thing, or is this something that you've been doing for a long time in terms of paying commission and holiday pay? I know there's organisations that have, and there's organisations that have kind of reflected it in an overall OTE as opposed to specifically calling it out on holiday pay. So just one for the room, if there's any good practice out there.
We don't have anybody that's on commission, so no.
Lucky you.
Yeah. Yeah.
It's not just commission, it's overtime as well, and also anything that's intrinsically linked. So that includes bonuses.
In that case, yes.
Yeah. So you have to look at your holiday calculations with all of those payments.
Mm-hmm.
And that's over the average. Now, Siobhan, you'd asked what happens, and we've done a survey of clients. Clients do weird and wonderful things, including one client that I have that does a balancing payment, and they've agreed this with the union, but because of Agnew and because of the changes on the 1st of January this year of working time regulations, it's not lawful. But I can say as a lawyer, it's not lawful, change it. Whereas practical is, if it's agreed with the union, what's the likelihood of any claims? And you just have to assess the risk. But what they do is they pay their basic salary and their overtime as part of their holidays when they're taken. But for any other allowances, commissions, they pay, or they've got a secondary overtime bit as well. And what they do is at the end of each year, they do a calculation to see how much an employee has earned. and how much they've calculated their holidays on and do a balancing payment. But that balancing payment is unlawful under AGNU and under the new working time regulations from this year, because holidays should be paid at the correct rate on the date that they're taken. If you do it that way, that's rolled up holiday pay and it's unlawful.
And there was another element to this, because the way that it used to be kind of done in terms of reflecting in it into a commission plan or an OTE or something, was that an employee should never be negatively impacted by taking annual leave financially.
Yes.
And that
Yes.
has gone. So whereas we used to be able to look at it and say, okay, we will pay you sort of on an average basis if it's obvious you took some time off in September and your pay was negatively impacted compared to when you didn't take time off. But that now doesn't seem to exist as a test. So you're almost in a position where you are paid more on annual leave
Yes.
than you are normally.
Yeah, and I mean it's one of those things that, AGNU as it applies in GB means that there'll be the tribunals and the courts will be able to look at a pragmatic approach to this to make sure that an employee over the period of 52 weeks is not any worse off. So in GB, it's a bit different because you can look at things like those balancing payments and the agreements with the unions and stuff like that. Whereas in NI, that's not the case under the new regulations from 2024, which say no, it has to just be the 12 weeks. You can't agree anything else, and it has to be payment at the date. So it's the detriment as the date you take the holidays. So Northern Ireland is more strict than GB.
Anyone put annual leave in anyone put annual bonus schemes in as well? So we have commission-based colleagues, but we also have annual bonus colleagues too. And obviously that's this new piece of legislation with it being intrinsically linked to performance. If you have a performance-based annual bonus scheme, we've had many a debate and many a call with employment lawyers as to whether or not we should or should not include that payment too.
If it's intrinsically linked to their performance, then it would be included. Okay, so if it's performance based, then clearly if they're on holiday, they don't have the ability to increase on that, so it should be included. The argument is whether if you say, right, we've had a great year, everyone gets £1,000 at Christmas, is that intrinsically linked to the job they do? Probably not. So it's the assessment of each one of the types of bonus that you have. Sorry, Katie, just reading your. Yeah, it depends on the type of payments. So if you get subsistence, and subsistence payment is for it's the same as the BM Williams case. If it's subsistence for being away from home or to pay for lunch vouchers or anything like that, then no, that's not included for holiday pay. I'm not sure if that's the correct answer, the correct question that I'm answering. Yeah, and in terms of when they work, then it depends on when they take their holidays. So if they take their holidays just after the very heavy hours in the summer, then they're entitled to their average of the hour of the pay that they've been given over the summer. And that means that if someone takes their holidays just after the summer period, then they get a higher holiday pay. If someone then puts off their holidays until November, then the average is going to be lower. So again, the way the regulations are written is, yeah, it can be a detriment to some people, and that's why the 52-week period or Agnew, as it's applied in GB, is more pragmatic in that, say, well, there are going to be peaks and troughs throughout the year, so let's look at it over a 52-week period, and that's a better average for the employees. In Northern Ireland, it's still the 12 weeks, unfortunately. Okay, there's also the other element of term time or part year working that has been eradicated by the new working time regulations in GB. But in Northern Ireland, if someone works part year, then they're entitled to 5.6 weeks at an average over the year. So the example given in the case law was somebody who comes in and does 1 week's work and gets £1,000 for that, an invigilator doing exams, for example, but they do that every year and they've got a contract that subsists. Then although they provide work for only 1 week of that year, they're still a worker for the 52 weeks and they're entitled to 5.6 weeks. And they're entitled to an average of what they've been paid. So if a worker works 1 week and gets £1,000, they're entitled to £5,600 in holiday pay. Still applicable in Northern Ireland, not so applicable in GB because of the changes there. Okay, so if you've got part year workers, you have to revisit the contracts and make sure that that's not going to be the case. Okay, holiday pay, family friendly. I'm not going to cover all of these. You'll know your duties for risk assessment for health and safety. Risk assessments for maternity should be as part of your normal risk assessments, but there's an additional risk assessment when someone tells you that they're pregnant, and that's to remove the risk. And if you can't remove the risk, then they're suspended on full pay until they are due to go off on maternity leave. Anthony, again, not covering these because it'll be all in your policies. Maternity pay broken in the statutory, which includes ordinary and additional, which is 26 and 26 weeks. And compulsory is 2 weeks leave that you must take from the date of birth of the child, or 4 weeks if you work in a factory. Notification, again, you'll know all that. You'll know about when to start. Keeping in touch days. Keeping in touch days were brought in because you're not allowed to do any work during maternity or adoption leave or whatever, because that breaks the maternity and you can't restart it. So they brought in keeping in touch days where you are able to break it and then restart it if it's a keeping in touch day, and that is 10 days throughout the period. Fine. One of the things that will be touched on in your assessment is the returning from maternity leave. So in your case study, Olga wants to return, but she wants to return on part-time hours. Under the legislation, you're entitled to come back to your exact job. Or if it doesn't exist, to another job on no less favourable terms. But also you have rights during your maternity to your terms and conditions, except for remuneration. And this is very important for your case study. So if you're looking at Olga, she wants to return on part-time. So we'll look at flexible requests in a minute, but she's also complaining that she wants her company car. So when she went off maternity leave, her company car was taken away from her and given to her replacement, Amina. Olga's now said, actually, I want my company car. So what you need to look at there when you're writing your answer, what is the contractual position of her car? If it is remuneration, it's not included. If it's a benefit, it is included, depending on the benefit. If the benefit is for business use only, then there's no right for her to have it when she's off on maternity leave, legally. from an ER perspective, different. Why would you take someone's car off them if they're on maternity leave? But if it's a benefit for business use and personal use, then that is a benefit to that employee, and they are entitled to that benefit throughout their period of maternity. So you can't take a car off them. Different if it's a maternity, if it's a car allowance, because then what you're looking at there is whether it is remuneration, and if it's remuneration, then you're not entitled to it. If it's a benefit, for example, if the allowance is in lieu of a car for personal and business use, then it's a benefit and you're entitled to that payment. Okay, so if I was looking at it, assessing that, I'd be looking at what is in her contract, what is the company car for, personal or business use. If it's just business use, then it's not a benefit. If it's business and personal use, then it is a benefit, and there's a right to it. So all of these things have to be taken into consideration when you're writing your assessment. The other aspect to that is, and this is where you get your higher points. If you're giving the car to Olga, you'll be taking it off Amina, and whether that benefit has been given to Amina as part of her contract, and therefore is that a variation to her as well. So all of those things have to be taken in the mix. Now, the other bit in terms of the maternity leave and Olga wanting to return is that she wants to return on part-time. There's no right in maternity legislation for that to happen because you come back on the existing terms, but park that until we get to flexible working. Okay. Not going to cover all of that. You can read that for yourselves. Adoption leave is the same as maternity, so I'm not going to cover that. Paternity, again, it's set out in the legislation in your policies. Shared parental leave, this was one that we used to spend a lot of time on. This is simply where you're allowed to split your 52 weeks. Not strictly true, you're allowed to split your 50 weeks because the mother still has to take the 2 weeks compulsory, and then you can split the 50 weeks, and that is between the two parents or adopters, and that is up to them how to split it. They can split it in one batch, or they can split it where they could take 10 weeks, 10 weeks on, split it 10 weeks, 10 weeks back on. Okay, so it can be split in various ways on agreement with the employer, and I've set out all of the various aspects of that for you. Okay. Any questions on those types of family-friendly leave? It's all pretty standard now. Everyone knows how much you take, how much you're paid, what notices, and when you come back. So very standard. One thing that does crop up on family friendly, and again related to your assessment, is flexible working. And this is where an employee has a right to request flexible working. And this is due in Ciara, in the Republic of Ireland as well, when we're still waiting for the code of practice to come out on this. But in GB in Northern Ireland, there's a right where you can request it. And there's various ways you can request, such as Olga asking for part-time work when she comes back. And there's a procedure to follow. The procedure is different in GB as it is in NI. NI is still very specific in terms of the dates when things must be done by. In GB, it's all very within a reasonable time scale. Okay, but it's the same sort of concept. A written application from the employee, and they must state that it's a request for flexible working. Bear that in mind when you're thinking of Olga. they must confirm they're eligible for it, so have the requisite length of service. They must specify the pattern that they request, and they must set out the effect that this has in the workplace. Again, this is removed from GB. Now, what must you do? As an employer, you must consider it. This is NI based. If you accept the application, you just write to them and say, yes, we accept it. And if that happens, you must accept it either as a permanent change to the contract of employment, or you can say, we accept it, but let's look at a trial period for 6 months, 12 months, and then we can decide whether to revert back. But if you are making changes to the application, or you're not going to accept it as written, then you must have a meeting within 28 days of the date of the application. The employee has a right to be accompanied by another worker. When you have the meeting, you discuss the reasons for the application. You discuss what issues it'll have for you as an employer. You look at the type of role that's been done. You look at how you can fill the other hours that aren't being worked. And then you issue a decision within 14 days. And what you can do is consider alternative working arrangements with the employee, or you can consider a trial period. Okay, and all of that would be through your meeting with the employee to discuss what would be agreed. But yes, you must set out your decision. Okay, an employee who fails to attend the meeting more than once, their application is treated as being withdrawn. When you're thinking of a decision, you must set out your decision in writing, but it must be not just that we don't accept it, or we accept it another time, whatever. It has to set out the specific grounds for the rejection. So if you accept it, but there's changes, you must set out the description of the new working pattern that's been agreed, and state the date when it starts from, and also whether there's a trial period. If you reject it, you must set out the business grounds for refusing it, and that's set out in the regulations. And you must set out a sufficient explanation to the refusal. So if you're saying, well, it's because of business needs, you must set out what those business needs are. If you say, well, the reason for refusing is that we wouldn't be able to cover that specific pattern, you must set out how you've looked at that pattern and the lengths that you've gone to try and consider whether that could be covered or not. So if someone says, I want to work 4 days, you might have real difficulty filling that with a temporary person or someone else within the team for that 1 day, and that would be enough then to refuse. If someone's part-time, you say, as is the case here, we can't fill it on a part-time basis. It's a full-time role. Well, how do you know that if you haven't checked? So it might be for Olga and Amina. Those people might be able to cover the full-time role part-time. Okay, so you have to be able to show that you've taken steps to look at that. The employee has a right to appeal, and you have to date the response. The business grounds are set out there for refusal. So, for example, burden of additional costs, that can't be just your number one. Not able to recruit additional staff, detriment on performance, detriment on quality, plan structural changes. So if you're going to be changing the way people work anyway, then you can say, we're going to park this now, we're going to refuse it because we are making structural changes in the near future. If you don't deal with it in accordance with the procedure, or you don't agree to it, an employee can go to tribunal, but a tribunal can't come back and insist that you allow the working. What they can ask for, what they can order, is that you can reconsider, or if they find that you haven't followed the procedure or that you haven't been reasonable in your decision, they can order compensation of 8 weeks' pay, okay, as the capped amount. Any questions on the flexible working? Siobhan, you'll obviously have to look at that from an NI and a GB perspective. but if you follow the NI, then it's unlikely that you'll fall foul of the GB.
Yeah, unfortunately I put it all in together, so I just have a UKI flexible working policy that follows the GB one, because I find that a bit more sort of generous from a colleague perspective.
Yeah, it is. But if for example, you didn't send your response within 14 days of the meeting, then you fall foul of the NI regs.
Okay, because that's specific. I think ours is 3 months, about to become 2 months in the spring legislation.
Yeah.
I didn't realise that yours was 14 days.
Yeah. Okay, there's also a new Domestic Safe Leave Act. So this is termed the rights on flee. So if someone has to, for example, flee their home for an emergency, try and find other accommodation and stuff like that, then there is a right to time off paid for that purpose. Okay, I'll leave you to consider that yourselves, but you should have a policy on it. There was also in 2022 new parental bereavement leave brought in, which is 2 weeks after the death of a child aged under 18 or a stillbirth arising from 24 weeks of pregnancy. Okay, so again, I'll leave you to consider a policy on that. Employment disputes, nothing much to add here, because you'll be aware that in England and Wales there's the ACAS Code of Practice. In Northern Ireland there's the LRA Code of Practice, but we also have the statutory disciplinary and dismissal procedure, but not a statutory grievance procedure, which is under the LRA code. So steps for employers under the statutory dismissal procedure. Anybody know? What's step 1?
Investigation?
No, but that would be under the code that you would do that. And it would be under the case law for so the British Home Stores case law of what makes a fair dismissal, and also your Polkey decision on fair dismissals. Step 1 in the statutory procedure is your letter. So setting out what the allegations are, setting out as much information as you have from the investigation, and inviting them to a meeting where they'll be able to provide any information that they have or defence to the allegations. Step 2, what's it?
Is it to
Don't be
schedule the
quiet.
meeting? Schedule the meeting?
No, so they've got a right to attend the meeting. So step 1 is the letter inviting them to the meeting. Step 2 is the meeting and the decision arising from the meeting.
The right to appeal?
And step 3 is the right of appeal. Okay, an appeal does not, depending on circumstances, does not remedy any breaches of step 1 or step 2. Okay, so make sure you follow that as a minimum. Now you'll have that in your procedures anyway, but that's always pleaded in cases. Also make sure that you follow the LRA Code of Practice, and that is the investigation, and also issues to do with witnesses and rescheduling meetings. Okay. Also consider in the codes of practice the levels of manager that can deal with things. So for an appeal, it should always be, as far as possible, a higher manager than the person who took the decision to dismiss. If you don't follow the ACAS or the LRA codes of practice, there can be an uplift or deduction, uplift or reduction in the compensation offered. So if an employee, for example, doesn't appeal the decision, but they take a claim, their compensation can be reduced between 10% and 25% in GB, or 10% and 50% in NI. And that's the same for any breaches by the employer. So if you don't allow a right of appeal, for example, or your step 1 letter doesn't meet the requirements, then there can be an uplift up to 50% or 25% in GB. Right to be accompanied, and this is an unfettered right. So the toll in GB Oil said that it's up to the employee to decide who they want. An employer can't refuse on the basis that they don't like the companion that's been chosen. You're not entitled to a legal representative unless there's some sort of career risk. For example, if you're dismissing one of your accountants for fraud, then it's likely that that's going to impact on their professional career, and therefore they may have a right to legal representation. Unfair dismissal, and this is the issue that may come up with Amina, because one of the guys in work doesn't like Amina, he wants her sacked. You can only sack someone if there's a right, if there's one of the potential fair reasons for dismissal. And that is set out in the Article 126, the right not to be unfairly dismissed, and the potential fair reasons under Article 130 of the ERO. But even though you have a fair right, and the fair rights are, off the top of my head, conduct, capability, redundancy, a statutory reason, for example, not having the right to work in the jurisdiction, or some other substantial reason, okay, breach of trust and confidence, for example. Even though you have one of those fair rights, fair reasons for dismissal, it has to follow a reasonable approach. So did you carry out an investigation, for example? Did you consider any alternatives to dismissal? In redundancy, did you consider alternatives to redundancy? All of those things are taken into the reasonableness of the decision. But also you've got Polke. So for example, if you have the fair reasons, you've followed your procedure, but you haven't followed it correctly, Polke as a decision says that had you followed your procedure and the person would have been dismissed anyway, then there's a reduction or no right to compensation. Okay. Now, I'm going to cover quickly discrimination law, and it's only going to be the concepts. These are the protected characteristics. So it covers everything from age, sexual orientation, gender reassignment, sex. What about gender? Is gender covered?
Yeah.
No, specifically in Northern Ireland. Actually, in UK, gender is not covered. Sex is the protected characteristic, but gender could be covered under some of the other rights, such as philosophical belief. It could be under sexual orientation, or it could be generally under sex. Okay, but gender isn't covered specifically. Gender reassignment is, but only if you're going through or about to undergo transition under medical supervision. Again, that's different, Siobhan, in GB, where there's no need for medical supervision, so you can self-identify GB. Sexual orientation, religious belief or political opinion, and that also includes philosophical belief, disability, age, marital status, maternity. Okay. Now, who's protected? It covers pre-employment, so this attracts to applicants as well as employees. So that's why you have to ensure your recruitment procedures are set out correctly. And the concepts in discrimination law are: one, direct discrimination, and this is where someone is treated less favorably because of their protected characteristic. Okay, you need a comparator, so you have to show that there's treatment, and that treatment is less favorable, and you have to show that it's on the grounds of the protected characteristic, and it can't be justified except in age discrimination. Indirect discrimination is where a person is treated less favourably because of the application of a provision criterion or practice, and this puts the protected characteristic at a particular disadvantage with others who don't share that characteristic. Okay, but an employee does have a defence in that they show, well, the PCP was proportionate to achieve a legitimate aim. For example, in the fire service, where they said you have to be able to carry a certain weight and you have to be a certain height to be a firefighter. Clearly, both of those had a disadvantage for women. It's going to sound very sexist, but women couldn't carry the same weight as a man, and women were traditionally smaller than men. Okay, so it had a detrimental impact on women. So it was indirect discrimination. Is that right? Is that correct? So do you remove your height restriction and your being able to carry a certain weight restriction?
Not if it's fundamental or if it's a health and safety issue, I guess.
Yeah. So the height was deemed to be indirect discrimination that wasn't justifiable, but the ability to carry a certain weight was for health and safety reasons, but also for the fundamentals of the job, where the judge said, well, if I'm in a fire, I want a firefighter to be able to run up the ladders, throw me over the shoulder and get me down. Okay, so that was seen as legitimate. Victimization, this is always confused with harassment, but this is where a person is treated less favourably because they've done a protected act under the equality legislation. So, for example, if you've got an employee that claims or puts in a grievance for race discrimination, and some other employee comes and gives a witness statement to say, yes, actually, I've seen they have been subjected to this, and you discipline or treat that witness detrimentally, they, as well as the other employee, have a right to claim victimization. Okay. Harassment is where a person engages in unwanted conduct and does so with a purpose or effect of violating their dignity or creating an intimidating or hostile work environment. You don't need a comparator, and it doesn't have to be about the person's protected characteristics. So, for example, if I'm sitting in a lunchroom with a group of employees and they're making jokes about a gay employee, I can bring that even though I don't share the same sexual orientation as the person they're taking the piss out of, because it's creating a hostile environment for me, even though I'm not trans, or even though I'm not Black or Jewish or whatever. If someone is creating a hostile working environment because of a protected characteristic and it harasses me, then I can take a claim on the grounds of harassment. Perceptive discrimination is if I treat you less favourably or harass you because I perceive you to have a characteristic, even though you don't, I can still bring a claim on that basis. Or, as we've explained earlier, associative discrimination. If I associate with someone who's trans or Jewish, then I can bring an associative discrimination claim if I'm treated less favourably on that basis. Disability I'm not going to cover with you, but just to, if you can read the slides on the reasonable adjustments and reasonable accommodations in the Republic of Ireland, then there's specific rights there. Now, I've got two things to cover: redundancy and TUPE. Redundancy I'm going to cover briefly, and that's simply to say there's a difference between individual and collective redundancy. Individual redundancy is where there is less than 20 employees. Again, Ciara, different in the Republic of Ireland, where it's based on percentages of employees within the workplace. But if you meet the collective requirements, so if it's 20 or more in in GB or NI, then you have to follow the collective procedure, and that is the election of representatives, the provision of information to representatives, and a period of consultation with those representatives. And for 20 up to 99, that's 30 days in GB and NI. For 100 plus, it's 30. It's 45 in GB and 90 in 90 days in Northern Ireland. And during that period, you must engage in effective consultation with a view to minimise the impact or to reduce the numbers of redundancy. Now, that's all set out in the legislation, so it's easy to follow. If it's individual, so if it's less than 20 or less than the provisions in the Republic of Ireland, it still means that you have to consult, because this goes down to the reasonableness of the dismissal. And that means carrying out a process where you inform the employees in the pool that they are at risk, and allow a period of consultation with each of the individual employees. So they might come forward and say, actually, do you know what? We've been discussing, and if 2 of us go part-time, and that reduced the amount for getting rid of 1 person. So it's effective a meaningful consultation, even though there isn't a collective approach there, which will show the reasonableness. Now, a new case, I'll just find that for you, over the last few weeks, has put a bit of a higher burden now on individual consultation, because traditionally what you would do is you would go to the group or the pool that was affected, and you would do your consultation with that. But this case now says, well, why wouldn't you go out to the wider workforce? Because there may be some information there that might be useful in considering the need for redundancy anyway. So this decision was Mogane, M-O-G-A-N-E, and Bradford Teaching Hospitals, an EAT case. And this was that there wasn't a consultation beforehand about a single selection criterion. Okay. And also there's other guidance in the case of DeBank Haycox on that. So on the basis now that what the EAT said was, even though you might have a pool that is affected, by just looking at the by just looking at that pool, you don't get the wider feel for what's happening in the organisation. Now, that doesn't mean that it brings in collective consultation by the back door. What it means is that you'll have to look at what's happening in the workplace. So, for example, if you've got a workplace of 50 and you're making 15 people redundant, then clearly you might want to inform and consult with the 50. But if you've got a workforce of 5,000 and you're making 10 redundant, then it doesn't make sense to go out to the 5,000. But you might want to say, well, what's the wider pool that we could consult with? So what we're saying to clients is, consider it on an individual basis. How many are you making redundant? What's the nature of the redundancies being made, and whether there's a wider pool there that you would consult with. But if you read the case of Mogane and also the case of DeBanks, I'll send you this link as well to that. What it says is, if there's a lack of genuine general workplace consultation, then that might lead to a decision of unfairness. But we've also got Polky. So even if the procedure is unfair, what we would argue is, if we did consult more widely, it's likely they would have been made redundant anyway, and therefore there's no compensation. Okay, but that's a consideration.
And I guess in practice as well, how does that work from a confidentiality point of view, like in terms of going out to the wider business to discuss proposals that may impact other people's employment?
there's no issue of that, because it would be a requirement, you would say, for good practice or under employment law to do it, and therefore there'd be no issues of confidentiality. What you'd be saying is we're looking at reducing 5 roles in this type of job duty, but there's transferable skills across 20 of you, and therefore we think it's important to look at that. I think it really widens the pools as opposed to collective consultation. Now, I'm not going to cover 2B because it's not part of your assessment, and a lot of people don't cover it in the rules anyway. So I'll not do that unless you have any questions. I'll be hanging around anyway. But what I do want to cover, we've got 5 minutes, is to look at your assessment and to give you some tips of how to deal with that. So the assessment in itself gives you a scenario, and this is whether so there's a level 5 assessment that's different than the level 7, but you approach it in the same way. You're looking at what the scenario is, and what I did when I looked at it is write down what the heads of claims are. So, for example, if you're looking at the use of Olga's use of the company car, whether this is a benefit under the maternity leave regulations. So that's what you're looking at. And then you look at the practicalities. For Amina, who's working 10 hours a day, you want to be considering whether there's any breaches of working time regulations. You're looking at the Section 1 statement. You're looking at whether that's been issued to Amina. If not, what does the Employment Rights Act or the Employment Rights Northern Ireland Order say about that, and when it must be issued and what it should contain, and what remedy she would have for not issuing that, which would be I think it's 4 weeks or 8 weeks pay. There's also a complaint of temperature in the office, and for me that's the health and safety at work regulations. And if you look on the gov.uk website, it sets out the temperatures that you would be looking at. So it's a risk assessment that would need to be carried out on that to see what the temperatures are, and if the temperatures are too low, what actions are you going to take to deal with that. Replacement of holiday pay due to sickness, we've covered that with the ANGID and the PARADA. So what you're looking at there is mentioned in the working time regulations, what someone's entitled to, but also those case laws of carrying over when someone is sick during holidays. There's also an issue which we didn't cover because it's not strictly employment law, is the access to the reference. If you look at the guidance under the Information Commissioner Office, it sets out what happens for a reference. The guidance under that on that website doesn't take into account the changes for the Data Protection Act in 2018. It covers the 1998 data protection. There is a specific exemption for references under paragraph 24 of Schedule 2 of the DPA. I'm not going to tell you what that is because I can't tell you the answers, but there's specific requirements for references. So someone can put in a data subject access request, but you have to look at whether references are exempted. Okay. So for that, what I'd be saying is she would have a right to request access this under the DSAR, but there are exemptions which include, and then you're going to what that says. There's a threat that Tony will leave if Amina isn't sacked. If you look at what we've said about the unfair dismissal rules, is there a potentially fair reason for her dismissal? Probably not. What's the fair procedure we followed? Are there any discrimination elements to that? Amina is of Asian race. Amina is female, and therefore there's protected characteristics as to why Tony wants her dismissed. Termination of fixed term contract in any event. Amina is under a contract that doesn't have an early termination clause. This brings in the issue of county courts and breach of contract, wrongful dismissal. If you're under a fixed term contract and there's no express right to terminate early, then that can lead to a wrongful dismissal case, which would lead to damages for the duration of the contract. Okay, so typically in a fixed term contract, if you're writing it for your own organization, you would put in its fixed term, subject to the termination clauses within the contract, and you'd be able to set out if there's early termination, for instance, given a month's notice. Okay, so we'll leave you to look at that with Amina. And also Olga's wish to come back from to a part-time post, and that's the bit that we've covered in the flexible working requests and the process for doing that. Any questions? Anyone going for a lie down in a darkened room? Any questions? Now's your time to ask, because it's going to go back and write the. I will send through to Lindsay the links to the resources that I think you'll find useful. And that'll be from the Lewis Silkin website, but also from other areas such as gov.uk and ICO. So I'll send those through to you, which will be useful. Any questions, go through to Lindsay and she can let me know and I can catch up with you again. For those who are too shy to ask anything on the call. So if there's no questions, we'll leave it there. Lindsay, anything that you want to cover for the? I think Lindsay's gone to sleep. No? Okay, well that's you. It's 1 o'clock, so thanks a lot for your time today. And good luck with your assessment.
Thank you.
Thanks so much.
Thanks a lot.
Bye.
Bye.